Ultimately, the judgment came in M. Nagaraj case, which is a 5-judge judgment. And this came on 19/10/2006. This Constitution Bench judgment, which was of 5 judges, it upheld the validity of the amendment of Article 16(4)A and 16(4)B. It said that it is not ultra-virus. But while holding so, the 5 judges bench, overlooking the 9 judges bench, gave certain conditions, imposed certain self-imposed conditions by the court, which is not in the Constitution. And these conditions were there, that are the 3 conditions which have been imposed in that. And these 3 conditions are that the states and the center, wherever they are making reservation rules or act, before making that, they will have to quantify, by means of a quantifiable data, word used is quantifiable data, they will have to ascertain 3 things. Number 1, whether their adequate representation in this service is there or not. Number 2, their backwardness will be ascertained by quantifiable data. Number 3, efficiency in the administrative work is being effected under keeping into mind Article 335 or not. Now, these 3 conditions imposed by M. Nagaraj case, I will come to that after narrating the incident which has led this House to consider and discuss on this issue today, and because of the judgment which came on 27th of April 2012, only a few days back in the last week. Now, after this, in the meantime, state of UP had brought this 1994 Act, which I had said under Section 37, there was a reservation, but UP government servant seniority rules of 2002 were also framed, and by means there was a reservation, but UP government servant seniority rules of 2002 were also framed, and by means of which in the 2002 rules, which were incorporated on 18/10/2002 in state of UP, when Shri Mayati ji was the Chief Minister of Uttar Pradesh, thereby Rule 8A was inserted. And this Rule 8A provided nothing else except what was already contained in the 85th Amendment. It said that so far as the reservation is concerned, promotion, the seniority would, accelerated seniority would also be, consequential seniority would also be available to those who have been promoted by means of reservation in promotion. Now, this Rule 8A and Rule 37, now after this, after the change of the government in Uttar Pradesh, on 13th May 2005, when the government of another party was there in power, on 13th May 2005, the state of UP had deleted this Rule 8A from the rules. But thereafter, in 2007, fresh government was formed of BSP, where Sushri Mayati ji became the Chief Minister of the state of UP, and thereafter, immediately thereafter, on 4/9/2007, this Rule 8A was reinserted in the rules, providing that consequential seniority would be available, and this was made operative with effect from 16th of June 1995, when the 77th Amendment was brought in the Constitution, and when the 85th Amendment was brought in the Constitution. Now, this Rule 8A, as well as Rule Act Section 37, which is in operation since 1994, 18 years have passed. Now, under which promotions have been made, which promotions were continuing since 1950 before that, and they were only under 37 said that they will, the Section 37 simply said that whatever rules, whatever orders are continuing for reservation, they will remain in operation. Now, in spite of Indira Sahni's judgment, in spite of that, this 37 and Rule 8A were challenged by means of various writ petitions. One bench was filed at Allahabad bench and the other at Lucknow bench of the Allahabad High Court. The Allahabad High Court gave its judgment prior in time, and the Allahabad High Court, after considering the entire matter, held that this rule, this provision of Section 37 of the Act, as well as Rule 8A, are perfectly valid, and they cannot be declared ultra-virus in view of the provisions as contained in the amended Constitution. Now, after that, Lucknow bench gave its decision, and the decision from Lucknow bench was of the same number of judges as was of the Allahabad, that is 2 judges. But in spite of there being a judgment of the Allahabad High Court, which was binding, and if there would have been any difference, it could only be referred to a larger bench, but the Lucknow bench, two judges bench, proceeded further to decide the issue. And after hearing the parties, they gave a fresh judgment. And in that judgment, they declared both these sections as the section 3.7 as well as root 8A as ultra vires. Now these matters came to the Supreme Court. In Supreme Court, the matters were taken up, and the judgment has now come on 27th of April 2012. This judgment, which has come on 2012, it upholds the judgment of Lucknow bench while criticizing the Lucknow bench that they should not have proceeded to decide the matter by two judges, because two judges had already given a judgment at Allahabad and it was binding on them. But still, after criticizing this, they proceeded to decide the matter on merits and held that in view of the Nagaraj's judgment, which imposes three conditions, the five judges, and since it is a 5 judges judgment and it imposes three prior conditions before framing the rule or the act, and in view of another judgment in respect to the same, the matter relating to Rajasthan services, where Suraj Bhan Meena versus State of Rajasthan, which also came to the Supreme Court, since the Supreme Court in that has also relied on Nagaraj's case and the three conditions imposed therein and the dictum laid down therein, and have declared the rule of Rajasthan also as ultra vires. Therefore, following these two decisions of Rajasthan as well as Nagaraj's 5 judges judgment, they have upheld the Lucknow bench decision. And the consequence of this is very grave. The consequence of this is that persons who have been promoted belonging to the scheduled caste, scheduled tribes persons right from 1994 onwards, no protection has been given under this judgment to them. They are not being protected as protection was given in Indira Sahni's case. Indira Sahni case, the 9 judges had given a protection to all those who had already been promoted, and that their promotions will not be affected. But in this case, the Supreme Court has not given any protection to all these employees having been promoted for last 18 years and being in service, and their seniority having been given to them under Rule 8A right from 2002 and earlier and thereafter. So the net effect of this judgment is going to be, which places reliance on the Nagaraj's case, that if this judgment is on the enforcement of this judgment, not only employees of the thousands and thousands of employees of the scheduled caste, scheduled tribes who have been promoted in the state of Uttar Pradesh, but throughout the country. Rajasthan has already been a victim. Now throughout the country, all the employees who have got promotion for the last, ever since the 77th Amendment, which has come, all the rules and the provisions of the Act, they will be liable to be declared ultra vires, and lakhs of these employees would stand reverted to their post on which they were initially appointed. Now this, therefore, has created the situation, which is a very grave situation today. The effect of this was that the employees of the scheduled caste, scheduled tribes, not only in the state of UP, not only in the state of Rajasthan, but the whole of the country are highly agitated, and not only because it is not the existing employees who are going to be affected, those who will be getting, who are likely to get employment in future, those who are still studying, who are students, and they will be getting employment in future, their rights, future rights, are going to be also affected by this. So it's almost the entire scheduled caste, scheduled tribes community of the country which is affected under this, and therefore the urgency which was placed before this house by Sushri Mayawati ji when she raised this issue, and also which through her letter which she has given to all the leaders of the parties, including the Honorable Prime Minister and the leader of the opposition, and stating these facts and the repercussions which are going to arise out of this. Now the question arises, what is the effect of this judgment and how we can overcome it? This will be a question which I am putting to myself also. While considering this question, and which this house will have to consider, while considering this question, it has to be seen that a few things which are very important. There are 3 conditions which have been imposed. One is about backwardness, ascertainment of backwardness by quantifiable data with respect to scheduled caste and scheduled tribes. Now while giving this judgment, the 2 judges' judgments of Rajasthan and UP by the Supreme Court, they refer to the 5 judges' judgment, and they say that the dictum laid thereon in Nagaraj's case is binding. Now Nagaraj's judgment, which is M. Nagaraj judgment, which has been given by 5 judges, they have completely overlooked the 9 judges judgment of Indra Sahni.